Welcome to Module 11, Accountability. The GDPR has embedded the requirement of accountability into the data protection legislative framework. At the end of this module, you will have a basic understanding of risk assessments, data protection impact assessments, or DPIAs, data protection by design, data protection by default, and accountability. Seats R Us, a leading designer of sofas and chairs, are implementing a new invoicing process in their finance department. As well as streamlining the billing process, the team will use clients' personal data to create online accounts, where the customers can view their details. What do the teams involved need to do regarding data protection? Accountability can mean a number of different things, but simply it is the obligations with which an organization must comply in order to show and evidence their compliance with the GDPR. The regulators do not want organizations to see data protection as a tick-box exercise. Instead, they are looking to companies to show they have developed and embedded a culture of data protection within their organization. Companies should document their approach to data protection and explain their rationale when they make decisions about the processing of data. This is their accountability framework, and the evidence they can use to demonstrate compliance to the regulator. The GDPR takes a risk-based approach to data protection. In any situation where there is a risk to personal data, an organization should conduct a risk assessment. There are two levels of risk assessment: a basic assessment of the risk to personal data, and a data protection impact assessment, which is much more rigorous. A basic risk assessment is an objective assessment, which establishes whether data processing operations involve a risk, or a high risk. The assessment does not need to be onerous. However, it needs to be consistently applied in all situations, and give a reasonable determination of the risk. A basic test should include a definition of the purpose of the processing, a review of the necessity of that processing, and an objective assessment of the risk to the individual due to the processing. Where initial analysis flags a potential high risk to an individual's personal data, it should trigger the second stage of assessment. A DPIA is a more formal review of a system or process. It formally assesses all the risks to the rights and freedoms of the individual, and establishes the steps required to mitigate those risks. A DPIA would generally include a description of the nature, scope, context and purposes of the processing, an assessment of necessity, proportionality and compliance measures, the identification and assessment of the risks to individuals, and the identification of any additional measures to mitigate those risks. A risk assessment is a basic review of the processing taking place, the data being processed and the risk to data subjects. Organizations should conduct risk assessments on their data processing activities on a regular basis, and each time they commence new personal data processing activities, or when they implement new data processing tools. Example: a healthcare provider is commissioning an outsourced laboratory to test blood samples for markers indicating a number of serious illnesses which cannot be tested by the healthcare provider. In this case, a basic assessment would demonstrate that the new processing has benefits and is necessary because the provider does not have the means to complete the processing themselves. It would also show that there is a risk to the rights and freedoms of patients due to the nature of the personal data being processed. In this case, a more detailed review, called a Data Protection Impact Assessment, DPIA, would need to be conducted, which would look at the risks and identify mitigating actions. The output of the DPIA will become part of the project to implement the outsourced service. The GDPR requires data protection to occur at all stages in the life cycle of a system or process. During the design of a system or process, the controller should ensure that technical and organizational measures are implemented, which ensure data protection and adherence to the data protection principles, i.e. data minimization. In addition, the controller should implement a procedure to review the technical and organizational measures in place for existing processing, and where those processes are changed, to ensure that data protection principles are being applied. Data protection by design and default. Planning includes all activities that occur prior to the go-live of any new system or process. Data protection by design refers to the steps taken during planning to ensure data is protected. Processing includes all activities that occur when the system is live and during the manipulation of data. Data protection by default refers to ensuring that steps are in place to ensure data is secure during processing, and that only the data required for the processing is used. For example, companies often use data sources for payroll processing, which contain many fields that are not used. These should be removed, and only the data actually needed for the payroll process included. It is the responsibility of all data controllers and processors to maintain a record of the processing they complete. The accountability document should contain details of the data held, types of data, sensitivity, legal basis for retention and the retention period. The policies and processes in place to fulfill data subject rights, for example a DSAR and DPIA process. Details of how a data breach would be managed. Details of any tests carried out, for example a breach test. Evidence that DPIAs have been completed. The details of the organization's privacy policy. And details of the organization's registration with the supervisory authority. Answer to the question at the start of the module. The initial risk analysis completed by the CDPIAs team should show that, due to the complexity of the project, the financial data involved, and the risk to the data subject, due to the external-facing portal, that a DPIA is required. The DPIA will consider these risks and determine mitigating actions which will be part of the implementation project. In addition, the DPIA will look at the data protection principles and ensure that at each stage of the processing, the principles are taken into account. We will now ask you a short question. Some time will be left for you to think about the answer. However, feel free to pause the video after the question is asked to allow yourself enough time to think about the answer. The question will be answered shortly after. A health center is changing one of its processes, and the project team are considering if they need to complete a data protection impact assessment. No new data is required, but a number of new steps and movements between systems will take place. Is a DPIA required? Yes? Or no? The answer is yes. Whilst there is no new data being used, the complexity of the process is being increased, which leads to a great risk to the data. Consequently, a DPIA is needed. This is the end of our module, Accountability. You can now move on to Module 12, Supervisory Authorities.